Okay, thank you so much for joining us today. Today's webinar is the Deregulation of the Migration Act. Deregulation of Migration Agent Lawyers, Opportunities for Humanitarian Migration Law Practice. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, where the CLCQ office is located, the traditional owners are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and future, and acknowledge the important role that Aboriginal and Torres Strait Islander people continue to play in our society. As this webinar is being viewed by people throughout Queensland and Australia, I'd also like to pay my respect to the traditional owners of the land throughout the country and extend a really warm welcome to any First Nations Australians joining us today. So we're really pleased to welcome Kylie McGrath, the Principal Solicitor from RAILS, Refugee and Immigration Legal Service, to present today. And she'll be talking to us, as I mentioned previously, about the deregulation of the migration agent lawyers through MARA. I'll let Kylie tell you a little bit more about herself when I hand over in just a moment, but just a little bit of housekeeping first. So today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints have been emailed out to everyone who registered yesterday afternoon and are also available to download from our website, and the handouts. I'll upload them to the handout section of the GoToWebinar control panel in just a moment. There are two ways you can ask questions today. So you can press the button that looks like a hand and we'll see that hand go up as you did earlier. We can unmute you if you have a microphone so you can ask your question that way. Or the easier way is that you can type your question into the question box on the control panel on GoToWebinar and we'll read your question out at the end. We will try and hold questions to the end of the presentation. There is a lot for Kylie to get through in terms of content, so we'll do our best to make sure there is time for some questions. But if we don't get to your question, we'll try and address those following the session by email. There's also some polls today that Kylie will be running, so they'll appear on your screen and we'll read the questions out. Do your best to answer the questions. It's really great for engagement for Kylie to see where you're at currently and also check your understanding of migration law. So without further ado, I'll hand over to Kylie to start the presentation. Thank you, Kylie. And it looks like, Kylie, you're just on mute there.
Okay, start again. My name's Kylie McGrath. I'm the Principal at the Refugee and Immigration Legal Service. I'm presenting an hour-and-a-half webinar today on the deregulation of migration agent lawyers, opportunities for humanitarian migration law and practice. I work at the Refugee and Immigration Legal Service. We're a community legal service in Queensland. Sorry, I've just seen someone saying we can't hear, but I think that's been rectified. I imagine Carly will let me know if it hasn't. RAILS, the Refugee and Immigration Legal Service, is a statewide community legal centre that specialises in refugee and immigration law. We've been around for over 40 years. The key areas that we practice in are protection visas, refugee family reunion. We've recently started a small cancellation practice, and we also work with those who are relying on the family violence provisions of the Migration Act, which we'll talk about in a bit more detail. I'm the principal at RAILS. I've worked at RAILS for the majority of the last 15 years. I've also worked in disability and mental health law with QAI and our newest CLC ADA. QAI is also a CLC in Queensland for those who aren't attending from Queensland. I've also worked in immigration and refugee law in London and with the United Nations High Commissioner for Refugee in Geneva and Oxford. I would also like to acknowledge the traditional owners of the lands on which we all meet today, elders past, present and emerging, and all Aboriginal and Torres Strait Islander colleagues who've joined the webinar today. I recognise the country north and south of the Brisbane River as the home of both the Turrbal and Jagera nations. RAILS has been proud in recent years to work with the Kamilaroi and Gungari nations to contribute to the recent High Court precedent, which set out that Aboriginal and Torres Strait Islander people have a special status in immigration law. We hope that this precedent will protect some Aboriginal and Torres Strait Islander people from being detained in immigration detention in Australia, removed and deported. We acknowledge the work that must urgently take place to rectify systematic racism in our migration and legal systems. Okay, I'm going to turn off my webcam now just to make sure that everyone has the bandwidth that they need for good audio. Fantastic. Okay, so the learning objectives today are to communicate this significant change that has occurred in the regulation of lawyers, to provide a basic introduction to the structure of migration law, to introduce key information about the areas of migration law that apply to the most disempowered asylum seekers, refugees and migrants, and to provide some information about Rails, including the work that we do, how to refer clients to us, and volunteering and pro bono opportunities. The outline of the presentation will work through these 6 key topics. So first we'll be talking about deregulation. We'll move on to talk about a basic structure of migration law. We'll then talk about key areas of migration law that impact on the most disempowered asylum seekers, refugees and migrants. We'll work through key practice tools, talk a bit about Rails and direct you to some further resources. And throughout the presentation, if I'm referring to the Act or the PowerPoint slide has a reference to MA, that's a reference to the Migration Act 1958, which is the Commonwealth Act. And there's my email address if you need to contact me. Okay, fantastic. Let's talk about deregulation. Okay, the current state of the law is that a lawyer is prohibited from providing immigration assistance unless they maintain a parallel registration as a migration agent. Immigration assistance has a specific definition, and the definition set out in section 276 of the Migration Act. Basically, immigration assistance means preparing visa applications, sponsorships or nominations of visa applications, or requests that the minister intervene under certain powers in the Act, providing advice on any of those things, or preparing for or representing at merits review in relation to any of those 3 broad matters. Under the current system, a lawyer can provide immigration legal assistance without maintaining that parallel registration as a migration agent. Again, immigration legal assistance is defined, and it relates to those same elements that we spoke at above, but at the judicial review level. So immigration legal assistance, which is not currently prohibited, is assisting clients in the Federal Circuit Court, the Federal Court or the High Court in relation to these migration matters. From the 22nd of March, there'll be a significant change to the regulation of lawyers practicing in the area of migration law. On this date, the Migration Amendment Regulation of Migration Agents Act 2020, Commonwealth, will take effect. From this date, lawyers who are not registered migration agents will no longer be prohibited from providing immigration assistance. This will open up migration law as a field in which lawyers with appropriate expertise, supervision and within an appropriate structure can practice and or volunteer without the need for an additional registration. It's really important to keep in mind though that all the rules that apply to lawyers practicing in other areas of law continue to apply and will apply in migration law. Which means that any lawyer practicing in the area of migration law will need to have a practicing certificate. They'll need appropriate supervision, particularly if they hold a restricted practicing certificate. They'll need to maintain a reasonable standard of competence and diligence within the area of practice of migration law, and will need to work within a law practice as defined in the Legal Professions Act 2007, Queensland. The impact of this change varies for professionals based on what registrations and practicing certificates they currently hold. So what I'm going to do now is talk about the immediate impact of these changes, working through each of those broad categories, and then I'll move on to the impacts for the future and some practical ramifications of these changes. And this is the order that I'll be working through the different groups of professionals in. And so we'll start with lawyers who are not currently migration agents. So for those lawyers who are not currently migration agents, and so not practicing in the area of migration law, unless of course it's in relation to court work, you can now practice in all areas of migration law as a lawyer. You do not need to maintain a separate registration as a migration agent. So that's pretty straightforward, that element of the impact in terms of understanding what the impact might be on particular professionals. It's relatively straightforward as well for those who hold an unrestricted practicing certificate and are currently migration agents. So we'll talk about the impact on lawyers who are currently migration agents, starting with those who have an unrestricted practicing certificate. If you hold an unrestricted practicing certificate and you're currently a migration agent, on the 22nd of March, your migration agent registration will automatically cease if you continue to hold your unrestricted practicing certificate at that time. Things are a bit more complex for lawyers who are currently migration agents who hold a restricted practicing certificate. Your registration as a migration agent will not automatically cease on the 22nd of March. It will automatically cease as soon as you become the holder of an unrestricted practicing certificate. And once you do come to hold that practicing certificate, you have to notify the Office of the Migration Agents Registration Authority within 28 days of holding your unrestricted practicing certificate. And the Office of the Migration Agents Registration Authority, or OMARA, for those who don't know, is the professional body that regulates migration agents currently, and will continue to regulate migration agents, but will cease regulating lawyers who are not also migration agents from the 22nd of March. So for lawyers who hold restricted practicing certificates and are currently migration agents, there's a period of time in which you can choose whether or not to maintain your MIRA registration. So you've got an initial 2-year grace period to maintain a dual registration as both a lawyer and a registered migration agent while you're still on your restricted practicing certificate. You can apply for that 2 years to be extended for another 2 years in certain circumstances. So you can choose to maintain your migration registration, but you could also choose not to maintain it. And you might want to consider that, for example, if you're a lawyer, you're working in a community legal centre or a law firm, you're appropriately supervised, you might need to consider if there's any reason to maintain your migration agent registration, and your employers might also have an opinion about whether or not they want you to continue with your migration agent's registration. Okay, and then moving on to those who are registered migration agents and don't currently and are not eligible to hold a practicing certificate. In terms of your registrations and your professional registrations, the new changes won't impact on you. You will continue to be a migration agent after the changes take effect. There is a specific scenario that raises concerns that's highlighted by these new changes in the regulation of lawyers and migration agents. And this is a scenario where someone's a lawyer and a migration agent, but they'll no longer be a migration agent after the 22nd of March. And they're working in a migration practice, which isn't a legal practice. It's a practice run by migration agents rather than by lawyers. Those professionals and the people who employ those or engage those professionals really need to think carefully about whether there's an appropriate structure, whether the rules around lawyers working in legal practices are being met within that type of arrangement. Okay. All right, so that's the immediate impact when the law comes into force, approximately 1 month from now. So what does that mean in terms of next steps for people? It means that anyone who's not a migration agent from the 22nd of March 2021 who wants to become a migration agent in the future will need to complete a graduate diploma in Australian migration law and practice and pass a capstone assessment. This is quite a significant change because previously a lawyer could provide their practicing certificate and an AFP certificate, pay the fees and tick some boxes, and be able to be a migration agent. That will no longer be the case. Even those who are currently migration agents who cease to be migration agents on the 22nd of March will need to work through these studies and this assessment in order to become a migration agent in the future. There was a bit of a divided opinion at a recent CPD that I attended about whether there might be a late re-registration exception to that, and anyone who's in that situation is just asked to do their own research and make their own inquiries to determine if that might be the case. But as a general rule, anyone who wants to become a migration agent who is a lawyer after the 22nd of March will have to complete these studies and this assessment. Another key implication for the future would be someone who's a lawyer and has previously been a migration agent. If they want to establish their own practice, previously they had the option of establishing a migration practice, which wasn't a legal practice, and just working in that practice in their capacity as a migration agent only. That won't be an option in the future if a person's unable to be a migration agent, unless, of course, they do the course and do the assessment. Okay. So hopefully this is clear. It's pretty hard to gauge the audience on a webinar, but this is our brave new world. Okay, so just in terms of some day-to-day practical implications of the change in the regulation of migration agents, all lawyers who are currently migration agents are being asked to update their practicing certificates on the OMARA website. Lawyers in particular circumstances are being asked to specifically email this email address that's on your slide. You're asked to do so by the 27th of January, but if that hasn't happened, I'm sure doing it now is better than not doing it at all. So lawyers who hold restricted practicing certificates are asked to email OMARA and also to let them know which state or territory the restricted practicing certificate comes from. Anyone who's previously held an unrestricted practicing certificate but no longer does, and anyone who intends to cease to be the holder of an unrestricted practicing certificate before the 22nd of March. Other practical implications are that a new 956 form is expected, and we'll talk about that a bit later in the presentation as a general concept. But in terms of the deregulation, there'll be a new 956 form which will allow for lawyers to put their details on the form. That's upcoming and hasn't currently been made available. IMI accounts, there'll be some transitions to allow lawyers to access IMI accounts without having a MAN, which is how a migration agent would usually establish and log into an IMI account. From the 22nd of March, anyone who's currently a migration agent and lawyer and will no longer be a migration agent will need to take the title of migration agent and their MAN off their email signature and any of their other branding. And it might also be worth people in those situations logging on to their OMARA the day beforehand and printing out their CPD records, because currently it's quite a handy way of keeping track of some of your CPD. And I imagine that won't be available to us anymore. So print that out and keep your lawyer CPD records separately for your legal registration body. I just want to make really clear that I am just speaking generally about the implications of these changes to the law. If particular individuals are looking to identify how it applies to them specifically, please do your own research, get your advice if needed. And these are the bodies that may be able to advise you in these respects. So just by way of a summary, from the 22nd of March 2021, lawyers will be able to practice in the area of migration law without maintaining an additional registration as a migration agent. From this date, those with practicing certificates who are not currently migration agents will be able to practice in this area, providing they're appropriately supervised, appropriately diligent and competent and working in a law practice. For those who are currently migration agents and lawyers, if they hold an unrestricted practicing certificate, it'll automatically cease on the 22nd of March. If they hold sorry, did I just say unrestricted? If they hold an unrestricted practicing certificate, it will automatically cease. If they hold a restricted practicing certificate, they can choose to retain their migration agent registration for up to 2 years initially, or until they become an unrestricted practicing certificate holder, whichever of those two things is sooner. Okay, hopefully that has made clear to you the changes to the regulation of migration agents and lawyers. And now I'd like to move on to talking about the basic structure of migration law. But before we do that, I'd just like to get a broad indication of the audience and how detailed the knowledge of migration law is already. So Carly is going to run some polls for this purpose. Thanks, Carly.
Thanks, Kylie. Hopefully everyone can see that poll up on the screen. So the first question is, how much do you know about migration law? Nothing, a little, or a lot. So you can answer those that question there, and you can see that results are coming in. Up to about 54% responded. I'll give you another 5 seconds to pop your answer in, and then I'll share the poll. All right, just another couple of moments. And I'm going to close that poll now and share with the group. So hopefully you can see that on the screen. So we've got 13% don't know anything about migration law currently, 57% know a little, and 30% know a lot. So Kylie, did you want me to go to the next poll now?
Yeah, yes, please. So the 4 questions in this set would be very helpful. Thanks.
Great. So you should see number 2 there, which is whether you are currently or have previously practiced in migration law, yes or no. This is a nice quick one. So the responses are coming in very quickly. And I'll give you another 5 seconds to vote. Okay, great. I'm going to close that poll now as well and share the results. So we are bang on half and half, 50% yes and 50% no. So thanks for that. Now I'll go to our third question. So you should see this number 3 up on your screen now. If you are a lawyer not currently practicing in migration law, are you considering practicing once dual regulation ends? Yes, no, maybe, or not applicable if you are not a lawyer. All right, so those responses are coming in. So I'll give you another 5 seconds. Great. All right, I'll close that poll up now as well and share those responses. So we've got 26% yes, 9% no, 32% on the fence, and 33% doesn't apply to them. Thank you. And I'll go now to the final poll for this section. So if you are a CLC or representing a CLC and that CLC doesn't currently practice in migration law, are you considering practicing once dual regulation ends? And we've got the same response options as before, yes, no, maybe, or doesn't apply if you're not a CLC, for example. And I'll give you another 5 seconds to answer that one. Great. All right, I'll close that one up as well. And oops, I'll just share those results. Okay, great. So 12% yes, which is really interesting. 5% no, 28% are considering moving into migration law, and 55% are probably not CLCs or not able to say. So I'll hide that last poll now and hand back over to Kylie if you wanted to make any comments on those responses.
Great, thanks so much, Kylie. Yep, that's really interesting. I'll just try and pitch the content at all levels and see how we go. So we're going to move to the second part of the presentation, which is around the basic structure of migration law. Migration law is in an area of administrative law. It relates to government decision-making and the regulation of that decision-making. It's an area of law that's complex, voluminous, frequently changing, and politically charged. Migration law is federal law, and the key sources of law are as follows. So the key sources are the Migration Act, 1958 Commonwealth, the Migration Regulations, 1994 Commonwealth, case law, the Policy Advice Manual 3, which is often known as PAM 3, is a very detailed procedural manual maintained by the Department of Home Affairs. It's accessible to Legend. That's how we access it. I think it might also be accessible through LexisNexis, and access to the Procedures Advice Manual 3 was previously a requirement for maintaining a migration agent registration. I would suggest it will be really important for anyone who's a lawyer who's practicing in the area of migration law as well, to make sure that they have access to the Procedures Advice Manual 3. Ministerial directions are also a source of law in this area. And Section 499 gives the Minister power to make directions, which must be consistent with the Migration Act and the Migration Regulations. The key decision makers in this area are the Department of Home Affairs and the Australian Border Force. So at the administrative level, we've got the Department of Home Affairs and Australian Border Force. Merits review is to the Administrative Appeals Tribunal, either in the Migration and Refugee Division or the General Division, depending on the particular matter that's being reviewed. And there's also a merits review body called the Independent Assessment Authority, which is established to work with boat arriving asylum seekers and refugees. The parts of the Act that set out the key provisions in relation to merits review are Part 5, 7 and 7AA. There's also judicial review, where key decision-making takes place in this area. Judicial review happens in the Federal Circuit Court, the Federal Court and the High Court. Key provisions set out in Part 8 of the Migration Act. There are two really significant and I believe unique areas of judicial review in the migration area that lawyers and others need to be aware of. The first is that we have a privative clause. So Section 4741 of the Migration Act purports to exclude judicial review of decisions that are made under the Migration Act. But the case set out there in your slides has limited the impact of that section and said that where a decision is impacted by jurisdictional error, it's not a decision under the Act, and therefore the privative clause doesn't apply to it. So this means that if you're looking to bring judicial review proceedings in relation to a decision under the Migration Act, you need to establish that there's been jurisdictional error. Other broader grounds of judicial review can't be argued, and the jurisdictional error bar is very high. There's also significant provisions that regulate lawyers and others' conduct in relation to migration litigation. So Section 4861 says that a lawyer must sign and certify on reasonable grounds that migration litigation has reasonable prospects of success in order to file a document commencing migration litigation. And Section 486F and E set out that costs can be pursued against that lawyer personally or any other person who encourages someone to pursue migration litigation that doesn't have reasonable prospects of success. The other thing that might be worth mentioning when discussing judicial review is, of course, all of this review occurs in federal courts, so lawyers practicing in this area need to be listed as practitioners of the High Court so that they can practice in federal courts. Okay, we have one more set of polls that goes to decision makers within the immigration law space. So if you could run us through them, Carly, that would be great.
No problem. So I'll launch the first poll. So hopefully everyone's been paying attention. Are there any other decision makers in the migration framework? Yes, no, or unsure. So pop your votes in on the screen now. All right, coming through. We're up to about 47% voted, so I'll give you another 5 seconds to pop your answer in. And all right, so another couple of seconds and then I'll close that one and share the results. All right, great. I'll close that one off now. Hopefully you can see those results. So are there any other decision makers in the migration framework? 55% said yes, 10% said no, and 35% of you said you were unsure. So I'll hide that one. And would you like me to do the next one as well, Kylie, which is, can the Minister for Immigration personally intervene?
Yeah, yes, please. I think there's 3 questions,
yes.
is there, that relate to this theme? Thank you.
Great. So can the Minister for Immigration personally intervene to cancel a visa if AAT have decided not to cancel the visa? Yes, no, or unsure are the response options there. So I'll give you another 5 seconds to pop your answer in. Great, answers are coming through, which is fantastic. So another couple of moments to pop your response in. And I'll close that one off and share those results as well. So here we've got 76% of people saying yes, 6% saying no, and 19% unsure. Thanks for doing that one. So I'll just hide those results again and go to our final poll. So are there people who cannot apply for a visa unless the Minister exercises a personal non-compellable power to permit them? Yes, no, or unsure? Okay, those answers are coming in. Another 5 seconds there to pop your response in. Okay, great. All right, thank you. I'll close those the poll now and share that last set of results with you. So here we've got 68% of people saying yes, 14% saying no, and 18% unsure. So thanks so much for that, everyone. I'll hide those results and hand back over to Kylie.
Great. Thanks, Kylie. Great. So majority of people did identify the Minister's significant powers in this space. So personal, non-compellable, non-reviewable decisions by the Minister are increasingly a feature of the migration system in Australia. Various provisions of the Act allow the Minister to substitute favourable or unfavourable decisions and to allow people to apply for visas when they would otherwise have no option to do so. Great. Now I want to talk about foundational legislative provisions in this area. A key concept in the area of migration law is a visa. A person who's not a citizen must have a visa to be lawfully present in Australia. If not, they're unlawful. And if they're unlawful, they can be subject to immigration detention and removed from Australia. Applications must be made for visas. Some of those applications need to be sponsored or proposed by an Australian permanent resident or an Australian citizen, or potentially an organisation or institution. The legislative provisions that capture all of this are set out in the slides, particularly section 1891, which sets out that people are liable for detention and removal if they don't have a visa. And section 29 is the section which sets out the power to grant a visa. All visas have a name and they all fall within a class. The class might have other visas in it or it might not. All visas fall within a subclass and the subclass is unique. So there's just one visa in each subclass and each visa subclass is given a 3-digit number to identify that subclass. and each class is given a 2-letter description to describe them. So I've just put an example here on the slide of a way that a visa might be described. So one particular visa is a protection visa. A protection visa is a class XA visa, so it exists within the class XA, and it's a subclass 866 visa. So when we talk about visas, we're often talking about that last number, really. So it's a subclass 866 visa is a protection visa, for example. There are a number of ways to helpfully distinguish between categories of visas, and I've endeavoured to set those out in this table that's up on your slides now. One of the key distinctions is between a substantive visa and a non-substantive visa. A substantive visa is a visa of substance. It's a visa like a partner visa that has been granted because someone is the partner of someone else, or a child visa that has been granted because a person is someone's child, or a distinguished talent visa that's been granted on the basis of someone's skills and contribution to the economy here in Australia. A non-substantive visa is not a substantive visa. So they're often called bridging visas, and they're visas that are just in place until a certain event happens. It might be helpful to think of them almost like a waiting visa. So for example, a person who applies for a partner visa, if they don't have another visa at that time, will go on to a bridging visa or a non-substantive visa while they wait for a decision on their partner visa. If it's a positive decision, they'll go on to the substantive visa of the partner visa. If it's not a positive decision and they decide to go to merits review, their bridging visa will continue until 28 to 35 days after the decision at the merits review process. Another key distinction is between temporary or permanent visas. Permanent visas allow a person to stay in Australia indefinitely. Temporary visas allow a person to stay in Australia for a specified shorter period of time, or until a certain event occurs, such as the grant of another visa. For example, a person might hold a temporary partner visa up until the time that their permanent partner visa is granted or a decision is made on their permanent partner visa. Similarly, a person might hold a temporary visa, which is a visitor visa. That visitor visa might last for a certain period of time, for example, 3 months, and then the visa would cease at the end of that 3-month period. Within those categories of temporary and permanent, there are further categories that relate to the broad reason that the visa was granted. So key categories of temporary visas are visitor visas, student, family, skilled and humanitarian visas. And key categories of permanent visas are family visas, skilled visas and humanitarian visas. The names are fairly indicative that family visas are based on a relationship between an Australian citizen or permanent resident, broadly, and a visa applicant. Generally, this needs to be a very close relationship, like a spousal relationship, a de facto relationship, a dependent child relationship, or a parent relationship. Skilled visas are based on the skills that a person can apply in an Australian workplace. Humanitarian visas recognise persecution, substantial discrimination, or human rights abuse in a person's country of origin. They're granted to people who are not safe to return to those countries. Another key distinction is between onshore and offshore visas. This describes where a person needs to be at the time that they make an application for a particular visa. For an onshore visa, the visa applicant needs to be in Australia at the time the visa application is applied for. They may also need to be in Australia at the time the visa is granted. For an offshore visa, the visa applicant needs to be outside Australia at the time the visa is applied for, and they may also need to be outside of Australia at the time the visa is granted. I'm now going to talk about what needs to be established for a person to be granted a visa. For every visa, there's 2 broad categories of criteria that must be met. First, there's validity criteria, and then there's non-validity criteria or additional criteria. Validity criteria, so for each visa, and we've spoken about how every visa exists in a subclass exists in a class and is a specific subclass. So validity criteria are set out in Schedule 1 in relation to a class of visa. So all visas within a class have the same validity criteria, and they're set out in Schedule 1 of the migration regulations. There's also a key section in the Act, Section 46, that sets out key things that could preclude a visa from being a valid visa application, and Regulation 2.07 is also a critical section. If an application is not valid, so if the validity criteria aren't met and that can't be remedied, it's as if the visa application was never made. The visa application fee will be refunded, and any impact that lodging that visa application might have had on a person's status ceases to be the case. So a person may well become unlawful if the application for a visa that they made was invalid. Schedule 1, which sets out validity requirements, has the same layout for every class of visa. So it sets out the form that needs to be completed, the fee that has to be paid, how the application must be provided to the department, whether the applicant needs to be onshore or offshore when they make a visa application, and anything else of critical importance to the validity of the application. If the application is valid, it then needs to meet key criteria in order to be successful. Many of these criteria go to the heart of the visa application. So for a partner visa application, you need to establish that you are the partner of an Australian citizen or permanent resident. For a visitor visa application, you'll need to establish that you genuinely intend to visit Australia and then depart. And there's a range of other criteria as well, for example, health, character, and integrity provisions that will need to be satisfied. Okay, I'll now move on to the third key topic, which looks to outline some key areas of law, migration law, that impact on the most disempowered asylum seekers, refugees, and migrants in the system. Actually, I might go back and just give you a brief summary of that last section, just to try and pull it together. So in summary, a person who's not a citizen and is in Australia must hold a visa to be lawfully present here. If not, they can be detained and removed. Each visa sits within a broad class of visas, and each visa has a unique subclass, which is designated by a 3-digit number. There are a number of ways to helpfully distinguish between different types of visas, and this is whether they're substantive or non-substantive or bridging visas, whether they're temporary or permanent, the broad reason for the grant of the visa, for example, skilled or humanitarian, and whether they're onshore or offshore visas. To be granted a visa, an applicant needs to meet all of the validity criteria, which are set out in Schedule 1, as well as in other locations, as well as the criteria that are set out in Schedule 2, which are non-validity criteria. Okay, so moving back to the third part of the presentation around key areas of law, what I'd like to do is put on your radar some areas of migration practice that are targeted towards the most disempowered asylum seekers, refugees, and migrants. I hope to provide you with sufficient information that you could identify when a client might have a visa option in one of these areas. And on that basis, you could either refer the client appropriately, or you could undertake further research or training to assist that client within your own practice. If you practice in private practice, this might be on the basis of the payment of fees, or it might be a pro bono arm of your practice. The first area that I'd like to look at is those who fear to return to their country of origin. So there's 3 classes of visa that are targeted towards people in Australia who fear to return to their country of origin. These are known as protection visas, as defined in Section 35A. One of these visas is permanent, and that's the protection visa, which sits in Class XA and is a subclass 866 visa. The other 2 are temporary visas. So we have a temporary protection Class XD, subclass 785 visa, and a safe haven enterprise visa. And you can see the specific letters and numbers for that one there on the slide. The key validity requirements for these visas are set out in Schedule 1, And because these are protection visas, and protection visas are very political, and protection visas are very hard to successfully apply for, there's not only Schedule 1, but there's a range of other sections in the Act that impact on whether these applications are valid. And I've set out some of the key sections for you there in the slide. The validity requirements that are set out in Schedule 1 are the payment of an application fee, which is $40 unless the person's in immigration detention, in which case an application fee doesn't need to be paid. Making the application on a correct form, providing the form to the department in the correct way, providing a current residential address, and providing basic reasons why the person fears to return to their country of origin. When we talk then about the key additional criteria, I'm really just going to talk about the criteria that go to the heart of what these visas are. There's a range of other criteria that would need to be researched and applied to a specific client's circumstances. But to successfully apply for a protection visa, a person needs to be either a refugee, meet the complementary protection criteria, or be a family member of a person who meets one of those two definitions. So if we talk first about a refugee, we now have a codified definition of what a refugee is in our Act. Previously, we've referred to the definition under international law, but that's no longer the case except for very old applications. So the Migration Act tells us that a refugee is someone who's outside his or her country of nationality and owing to a well-founded fear of persecution is unable or unwilling to avail himself or herself of the protection of that country. What this means in practice is that 5 broad elements need to be established. The applicant needs to show that there's a real chance that they would be seriously harmed if they return to their country of origin. The reason that they would be harmed has to be one or more of 5 broad reasons. It has to be that the state, the country that they live in, can't provide adequate protection in relation to that harm, and that there's nowhere that the person could safely relocate within their country. What this means in terms of a real chance is it doesn't have to be more probable than not that a person is harmed if they return. Some of the case law says that there needs to be more than a 1 in 10 chance of that harm occurring on return. Serious harm are things like being killed, seriously physically injured, held in detention without proper oversight of the law, or economic deprivation that threatens the person's capacity to subsist. The harm has to be for one of 5 broad reasons, and these are the reasons that are set out in the Refugees Convention, and they are race, ethnicity, political opinion, religion, nationality, or membership of a particular social group. So these are the reasons that the person is being targeted for the serious harm. It has, in terms of the state not being able to provide adequate protection, the state isn't required to guarantee someone's safety. There's specific provisions in the Act that set out the standard that it's required in terms of protection, and a person's case needs to be referenced specifically against those sections. And it has to be that there's nowhere safely in the country that they can relocate. Complementary protection is also defined in the Act. The definition is set out for you there in the slides. The definition has key similarities and key differences as well. So to successfully establish a claim of complementary protection, a client needs to show, again, that there's a real chance, but the real chance is that they would suffer serious harm. They need to show that there are elements of their personal circumstances that mean that they will suffer that harm. They don't need to show that the reason they would suffer harm is for one of the 5 broad convention reasons, but they need to show that there are things about them specifically that set them apart from the population as a whole in their country. They must also show that the state can't provide adequate protection, and the bar for the state in terms of the protection that needs to be provided is higher. So as far as clients are, from a client perspective, it's easier to show that the state is not providing adequate protection if you're presenting your claims as a complementary protection claim rather than as a refugee convention claim. And then the person also has to show that either there's nowhere that they can relocate safely in their country, which is the same as with the refugee definition, or that it wouldn't be reasonable to expect them to relocate somewhere in their country of origin, which makes it an easier test to satisfy than in relation to the Refugees Convention. I've also set out on the slide what significant harm means. So there's a number of specifically defined forms of harm that make up what significant harm is when it comes to complementary protection. Of course, the client doesn't have to choose. So many clients would present their claims both in terms of the Refugee Convention and in, well, not the Refugee Convention anymore, in terms of our law, the codified definition of a refugee, and in relation to complementary protections as alternatives to each other. For many years now, there's been a visceral need on the part of the department and lawmakers to separate those who fear to return to their country of origin based on whether they have lawfully, under international law, entered Australia to seek safety by plane or by boat. If we return to this slide setting out the classes of protection visa, the first class of protection visa, these subclasses of protection visas. The first subclass, the permanent visa, is only available to those who've arrived in Australia by plane. Those who've arrived in Australia by boat can only access temporary forms of protection. The temporary protection subclass 785 visa is a 3-year visa. The Safe Haven Enterprise visa is a 5-year visa, with the concept that clients are required to re-establish every 3 to 5 years whether or not they still meet the definition of refugee or complementary protection in relation to their country of origin. The mode of arrival impacts on this, the length, whether the visa is temporary or permanent. It also impacts on whether people can bring family members to Australia. So anyone who's arrived in Australia by boat to seek asylum is unable to bring family members here to join them. And it impacts on the process through which a decision is made and the extent to which procedural fairness is afforded. So you'll see on this diagram, when we get to the merits review point, people who've arrived in Australia by plane access the Administrative Appeals Tribunal. People who've arrived in Australia by boat access the Independent Assessment Authority, the IAA, which is a review body where there's no right to a hearing, there's no right to present new information, and submissions are limited, like have a particular strict page number if they're provided to the assessment authority. Another group of clients in this category who've arrived in Australia by boat and fear to return to their home country are transitory clients. Transitory clients is a term set out in the migration law. It describes those clients who came to Australia lawfully under international law to seek asylum by boat, and they were transferred to offshore detention sites in Manus Island and Nauru. They were then transferred back to Australia, generally because they had significant medical needs which couldn't be met on those detention sites. And these clients are unable to make any application for an Australian visa unless the minister exercises a personal discretion to lift a bar to allow this to occur. Many transitory people are here in Queensland, as this was one of the key sites for medical transferees from Manus Island and Nauru. Just last October, 100 transitory clients were released from a form of detention into the community here in Queensland. If you're looking for further resources in relation to protection visas, I'd strongly recommend the AAT Guide to Refugee Law, which is really detailed and includes a lot of reference to key case law in this area. EcoINet is the meta website recommended by the United Nations High Commissioner for Refugees for up-to-date research on the situation, the human rights situation in countries around the world, which is how you'll research whether or not a person's subjective fears of harm if they return to their home country can be supported by objective evidence, or it will be a starting point for that at least. Okay. Another key area of migration law that impacts on those who are disempowered is refugee family reunion. This is just a broad description of work rather than a legal term for work that aims to reunite holders of protection and humanitarian visas with key family members who've yet to make it to Australia. When we're looking at refugee family reunion, unfortunately, as I outlined earlier, we're not looking at people who've arrived in Australia by boat. We're only looking at those who've arrived in Australia by plane. And there's two key groups in this respect. So there's protection visa holders, which we've just spoken about. So people who arrive in Australia by plane, and once they're here, they raise their fears of returning to their country of origin. In Australia, we also have holders of refugee and humanitarian visas. The subclass is XB visa, whose refugee or humanitarian visa was granted before they came to Australia. So a key kind of example of someone in this situation might be someone who was living in a refugee camp and was accepted by UNHCR to be a refugee and resettled to Australia, granted an Australian humanitarian visa and came to Australia on that basis. So one option for refugee family reunion is through what's called the split family provisions. The visa that is granted to these family members is a Class XB visa, and the subclass is either 200, 201, 203, 204 or 204, just based on the family member who's in Australia and what visa subclass that person here has. In terms of those validity requirements, they're set out in Schedule 1. Importantly, there's no application fee, and that's set out in Schedule 1, that the application fee is $0. In terms of those key additional requirements, the visa criteria that go to the crux of this visa are 5. So to make a successful application under the split family provisions, the person must have a family member here in Australia who holds either the permanent protection visa, which we spoke about, or one of these Class XB refugee or humanitarian visas, subclass 200 to 204. The visa application must be made within 5 years of that person, the one who's already in Australia, being granted their own visa. Before that person, the one who's here in Australia, was granted their visa, they need to have told the Department of Home Affairs about the person that they are hoping to bring to Australia and the relationship that they have with that person. And the relationship needs to be an immediate family member relationship. So that means it has to be the person's spouse or partner, their dependent child. It can also be their parent, but only if the person here in Australia is still under 18 years of age. While this option, the split family provisions, is technically available to those who arrived in Australia by plane and then claimed protection and was successful in being granted a Class XA protection visa, subclass 866, it's not practically a viable option. There's a ministerial direction which gives those people the lowest processing priority, and in the context of already lengthy processing times, it's just not, it's only something to be pursued if the client has no other option. Refugees who are here in Australia, who've arrived by plane, are also able to make applications for offshore partner visas. The subclass and classes of those visas are there on your slide. In terms of validity requirements, one of the key things to note is that that application fee is $7,715 if you're just bringing your partner over. If you have children that you're also bringing over, the fee increases by those amounts for each additional child. So it could be over $10,000 to make this application to bring a partner to Australia, which is why these split family provisions can be so important for those who meet the criteria. The key additional requirements go to the partner visa, the partner relationship. So the person here in Australia needs to be a permanent resident or citizen, and the relationship between the person here in Australia and the person who's still offshore needs to be a partner relationship. There needs to be a genuine commitment to a shared life together. And the department will look at the financial and social aspects of the relationship, the nature of the commitment, and the nature of the partners' households, of their shared households, to determine whether those criteria are met. There is also an option for visa holders here to sponsor children to come to Australia. The class and subclass are set out. The application fee set out in Schedule 1 is lower thankfully, $2,665, so that's sometimes still a prohibitive amount for people of refugee background. The key additional requirements are set out in Schedule 2. There are many, but the really core criteria are that the person must be the dependent child of the sponsor, which means they need to either be under 18 or over 18 and engaged in full-time study and financially dependent on the Australian sponsor. Another key visa that's worth keeping in mind is an orphan relative visa. You can see the class and subclass listed there in the slides. One of the validity requirements is the application fee, which is $1,630. And the core criteria for this one relates to whether the person is an orphan relative. The relevant definitions are set out in the regulations on the slide. But basically the person needs to be under 18. The application must be made before the person turns 18. The applicant, the offshore applicant, needs to not have a spouse or de facto partner, and it must be the case that they can't be cared for by either of their parent because both of their parents are dead, permanently incapacitated, or unknown whereabouts. The person outside of Australia needs to have a specific relationship with the person here in Australia. They need to either be the brother, sister, grandparent, aunt, uncle, niece, or nephew of that person. This visa option and the two before it are not limited to people who hold refugee or humanitarian or protection visas, though I imagine the orphan relative visa application might be more utilised by that client group because of the circumstances that they flee than by the more general population. Okay. So in summary, here in Australia, we have people who hold protection visas, refugee and humanitarian visas. A number of them are separated from family members who are still living offshore. There are some key options through which they can look to bring family members here to safety in Australia and to be reunited with their families. One of those options is specific to holders of permanent protection visas or refugee and humanitarian visas set out in this Class XB, and that's the split family provisions. And three of the other key options are general family stream options, which are available to anyone in the Australian community who's a permanent resident or citizen, and may be utilised by refugees in certain circumstances. Okay. Another broad category here is those who've experienced family violence. So an experience of family violence can have a positive, negative or neutral impact on the visa status or visa of a person who's here in Australia. A key area of interaction between the experience of family violence and migration law is known as the family violence provisions. The family violence provisions apply to partner visa applications, which are still in the process of being determined. There are some complexities to partner visa applications that need to be explained in order to understand where the family violence provisions are located. So if we just take a step back and talk about partner visa applications can either start when the person is inside Australia. Sorry, this is the visa applicant. So we've got an Australian citizen or permanent resident who's here in Australia, or may not be, but let's say they are, and they have a partner. Their partner could be outside of Australia, in which case they would apply for an offshore partner visa, or their partner may be inside Australia, in which case the application would be for an onshore partner visa. When they make that application, they apply simultaneously for a temporary partner visa and a permanent partner visa. The first thing that happens is the department will look at the temporary partner visa application, and they may grant, if they feel that the criteria are satisfied, they'll grant a temporary partner visa. At that point, if the partner was previously outside of Australia, they will travel to Australia on their temporary partner visa. The person who's applied for the visa needs to wait at least 2 years from the time that they applied for those visas initially before the department will even start to look at their application for a permanent partner visa. Processing times can be really lengthy. At the moment, the department has on their website that 75% of those onshore partner visa applications are taking 3 years to be processed. In our experience, that can be much longer, particularly if merits review is required as part of the process. So while on this pathway, and you've got a bit of a diagram there on your slides, while somebody is waiting for their permanent partner visa to be granted, it may be that they experience family violence. The general rule is that the person needs to stay in that relationship right up until the department process the permanent partner visa. If they leave the relationship prior to that time, the visa application will be refused because they will no longer meet the criteria that they are the partner of the Australian citizen or permanent resident sponsor of the application. There's 3 exceptions to that rule. One is the death of the Australian partner. The second is the child relationship exception, and the third is the family violence provisions. The family violence provisions mean that if a person experiences family violence during their relationship, before their permanent partner visa is granted, so before they get to these final rectangles at the right-hand side of the screen, they can continue with their application for a permanent partner visa, and they can be granted that visa despite the fact that they're no longer in the relationship. What they would need to establish is that the relationship was genuine before it ended, or that they need to establish 2 things: that the relationship was genuine before it ended, and either that they have a child of the relationship or that they experienced family violence in the relationship. If they have experienced family violence, they need to evidence that either through judicial evidence. A key piece of judicial evidence is a final DVPO. There are other pieces of judicial evidence which can also meet the criteria here. If they can't provide a piece of judicial evidence, they need to provide non-judicial evidence. If they're providing non-judicial evidence, they need to provide a detailed statement of their experience of family violence, as well as 2 pieces of non-judicial evidence, which could be, for example, a medical report by a medical professional, a statutory declaration by a psychologist or a social worker, or a letter on letterhead by a refuge or specialist crisis organisation working with family violence, with those who've experienced family violence. Okay. The 4th area of law that I want to talk about under this heading is in relation to cancellations. Cancellations are increasingly a common feature of migration law. There's some quite alarming graphs that show huge increases in the number of cancellations when a key change in law was introduced a few years ago. Visas can be cancelled or refused on the basis of identity, integrity, or character. There are key cancellation powers set out in the Act. Section 109 relates broadly to incorrect information. Section 116 is a broad provision that includes things like general conduct, and Section 501 is a criminal cancellation provision, which includes provisions where visas are automatically cancelled in particular circumstances where clients are in criminal detention and have been sentenced to 12 months or more of a custodial sentence. Okay. All right. Moving along to some key practice tools. If you're practicing in the area of migration law, you're likely to access these tools. So Legend.com is a site that is a paid subscription site. It includes the Act, the regulations, the Procedures and Advice Manual 3, PAM 3 that I spoke about earlier, and the directions. They're all hyperlinked between each other so that you can go from a section in the Act to the relevant definition in the regs and then to what the policy says about it all. It includes forms like application forms for visas, which are fillable and savable, which distinguishes them from the ones on the department's website, which you can fill but you can't save. Yes, so Legend is a resource that people practicing this space may wish to access. Vivo is a practice tool that organisations and practitioners can register for, where you can check a person's visa status, whether they have a visa, when their visa expires, whether there's conditions on that visa. It's important to get consent from clients before using Vivo in relation to them. The department does keep records of who conducts Vivo checks and when they conduct them. And we have seen references to those Vivo checks in refusal letters. You can register for an EMI account that will allow you to lodge visa applications and to add new documents onto visa applications as they become available or as they're requested. In the migration space, there's a specific form that you need to use to inform the Department of Home Affairs that you're representing a client. Obviously, this is a new space, but it's given that the Form 956 will be updated, my sense of it is that the department isn't going to accept a general kind of authority to act on behalf of someone. That authority to act is going to need to be expressed specifically on a Form 956 in the migration space. And you can make a freedom of information request, and there's a hyperlink there for that to access previous documents held by the department about a client. Okay, I think we're going relatively well for time. I do want to leave time for questions at the end. So we'll move quite quickly through key practice tips. In this space, you're likely to be working cross-culturally. For me, the key thing for working cross-culturally is not to make assumptions, to be really mindful of what assumptions you might be making in the way that you're expressing yourself, and how you're understanding what's being expressed to you. It's important to consider trust, dress, physical contact, shame, mental health conditions, trauma, and gender when working cross-culturally. All of which is one of the reasons that I find working in this space so fascinating and challenging and engaging. Using interpreters, be sure to use interpreters when English is not the client's best or preferred language. You can access them through tiers, the hyperlink is there. You can pre-book a telephone or a face-to-face interpreter, or you can call and get an interpreter on the line. You'll need to establish an account with tiers so you can pay for that. Organisationally, be sure to continue to speak to the client directly, and to maintain control as the lawyer of the conversation, rather than letting the control slip to the interpreter. Always really important to explain that the interpreter needs to keep everything confidential to the client through the interpreter at the outset of the conversation. Okay, I really want to mention that consistency and attention to detail are fundamental in this space. Sometimes I think getting a visa is all about whether you can be consistent or not, rather than about whether, that becomes more important than whether a client genuinely fears harm on return to their country, for example, in relation to protection visas. As a lawyer or migration agent practicing in this space, it's essential to make sure that all of the information that goes to the department is true and correct, and that it's carefully scrutinised and cross-referenced. Otherwise, the visa could be refused, cancelled, the client could be detained or removed. They could be unable to meet criteria of future visas, or they could be subject to a ban for 3, 5, or 5 years. Actually, there might even be other lengths, but they could be subject to a re-entry ban in relation to future applications. Rails. We work in this, Rails' core area of practice. I set this out in the introduction, really. It's also there on the slides. We work at the department, merits review and court level. We have an advice service on Wednesday nights where we utilise volunteer migration agents and migration agents currently so far to work with financially disadvantaged clients across a range of priority areas. We also provide day advice through our solicitors to those who've experienced family violence. You can refer to us through our referral form and with those contact details. And we're always looking to engage with volunteers and pro bono partners to continue to do this important work with clients who are so disempowered by a system which can be very hard to get a successful outcome through. Here we've listed a number of opportunities for volunteering or pro bono engagement, as well as the best way to contact us in relation to those. So we'd certainly look forward to hearing from people in that respect. And the contact details of our pro bono coordinator, Stacey Parker, are included in this slide. Here's some information about further resources, including I might mention that Rails coordinates an asylum seekers legal working group on a monthly basis to help coordinate legal assistance services to asylum seekers in Queensland. So it may be very fruitful for others who are thinking of moving into this space to get in contact to join that group. And I'm also happy as the principal to speak to you about your plans in this space, and my email address is on that initial slide. I'm going to throw to my colleague Rob to speak about CPD, and then in that time I'll review some of the questions and see what I can answer.
Thanks, Kylie. I'm Rob Lakovich, the Education Officer at Rails. To those who are working or wanting to start work in migration areas, we just want to let you know that Rails runs a comprehensive continuing professional development program online in the areas of law, refugee and migration law that we specialise in. And these are held on the last Tuesday evening of each month from 5:30 to 7 p.m. Plus we have an intensive day in June. The program can be found on Rails website, education pages along with fact sheets on areas of immigration law that we specialise in. We also run a vibrant general legal education program for refugee and migrant communities, as well as with schools, TAFE, sector agencies and other groups, and we've created a range of innovative legal education resources which can all be found at www.rails.org.au/education. So if you have any questions about our CPD or other education, you can email me at education@rails.org.au. And back to you, Kylie.
Great, thanks. Okay, I've started to review the questions. There's not that many, which is helpful in terms of time. Just give me one moment because one has a few elements, so I'll just read through it. Okay, there's a question from someone in the audience about someone who previously held a refugee visa. The visa was cancelled on the basis of incorrect information, and they've appealed to the AAT, and they want to provide information to the AAT about all of the true and correct information and potentially make a complaint about a previous migration agent, but is worried about the consequences of that. If that person is in Queensland, that's within the scope of our new cancellation practice, which works specifically in the areas of integrity and identity cancellations for those who hold or have held refugee or humanitarian visas. So you could just refer that matter to us. The clients in the ACT, that's an interesting one. I think look, I'd be reluctant to give out information about what CLCs in other states can do, particularly when it's outside of the core state that they work in. I think I know which refugee community legal centre to direct that inquiry to see whether they can assist. Carly, is there a way that I can do that offline?
Yeah, absolutely.
Yeah, the person who's asked that question has my email address. So if you just wanted to email me, that might be an option. Or is there a better way of doing it, Carly? Maybe you can just let me know afterwards. We'll get that answer to you about which community legal centre might service the ACT in relation to refugee and refugee matters. I'll go on to some other questions. Yeah, so another question is, if an asylum seeker arrives by plane but isn't immigration cleared, can they apply for that permanent class XB, subclass 866 permanent protection visa, or would the TPV Chev regime apply to them? That's a really good question. They can only apply for the TPV Chev visas, you're correct, because they weren't immigration cleared. I guess that was just in the spirit of trying to provide clear, simple information in an hour and a half. I glossed past that, but thanks for raising it. You're correct that they would be accessing the TPV Chev temporary protection scheme in those circumstances. Looking at another question. Yeah, so the question is, if someone makes a false claim in relation to a protection visa application, can the department cancel another visa, so like a bridging visa application on that basis? And my understanding, without having the time to look at the specific wording of the legislation now, is that the provision that allows a visa to be cancelled allows any visa to be cancelled on the basis of incorrect information in relation to any other visa that the client has held. I'm relatively confident on that, but you could check the specific provisions, which you'll find in and around Section 109 in the Act. I think that's actually all the questions, Carly.
Thanks,
You don't
Kylie.
have any other questions that I'm not seeing?
There were a couple that came through when people registered. So I've written them down and happy to just read them out. There's just a couple of really quick ones,
Yeah.
one of which I think you may have already kind of covered in the content, but I'll just read it out for completeness. So Joseph has asked whether Omara registered solicitors on a restricted certificate will have to complete the grad dip in migration law and practice in order to continue practicing.
Okay, so you're a lawyer on a restricted practicing certificate and also a migration agent, is that right?
I think that's right, yeah.
Yeah. Okay, so to continue, so the answer is no. You can continue working as a lawyer. The changes aren't going to impact on that. You could also just move to working as a lawyer supervised in a legal practice, if that's your situation, from the 22nd of March. And in addition to that, your registered migration agent registration will continue after the 22nd of March for for 2 years initially, potentially up to 4 years. The only reason you'd have to do that course is if you become an unrestricted practicing certificate holder, then your migration agent registration will automatically cease. If you want to become a migration agent specifically in the future, you would have to do the course and the assessment. With the proviso that you might want to look into whether late re-registration gets you anywhere or not. And of course, that's not specific advice, it's just general information about the provisions. What else you got, Kylie?
So the other one is whether or how can criminal traffic matters impact visa eligibility? Now, I know you did speak about criminal matters of a certain kind, but whether the more minor sort of traffic incidents might have an impact as well.
Yeah, great. Okay, so really any character matter can have an impact on visas. It can impact on whether a person will meet the criteria for a visa that they apply for that they don't currently hold. It also raises a question of whether whether any visas that they currently hold can be cancelled. You know, it feels like there's like literally a copy and paste sentence for every type of criminal offence and why they're considered serious. We don't practice in criminal cancellation, so I don't know this area in detail. I would say that even in relation to traffic matters, there's no guarantee that it won't impact a visa, and that person should access migration advice about how likely it is those offences will impact on either their current visa or any visa applications that they have currently or that they might make in the future.
Great. That's all the questions that I've got. There were a couple of little clarifying comments just coming through the question box while we were talking, Kylie. So I'm not sure if you've seen those or whether there's anything that needs to be addressed in there.
Oh, sure. Okay, immigration cleared. Yeah, immigration cleared is a term in the migration law. It basically refers to getting through the airport. So if someone arrives in Australia, and there's obviously other entry points as well. Okay, so if we're talking about an airport, if someone arrives in Australia, for example, in a passport or in a visa that's not in their name, but they make it through the airport, get their bags, go through customs and leave the airport, they've been immigration cleared. If they arrive on the plane and they get pulled aside before they make it all the way through and questioned and put in immigration detention, then they haven't been immigration cleared. Similarly, when people arrive in Australia by boat, they don't get immigration cleared. So it's a term with a specific definition that broadly means whether you have passed through a certain point in the border with integrity or not. Hopefully that's clear. Yes. Yep, that's what I've got on that one. Yes, does not correcting records impact on subsequent visa applications? Often, yes. So there's provisions in the Act that say that, yeah, actually it's correcting records. So yes, absolutely. There's an obligation to correct incorrect information, which continues even after a visa has been granted. Yeah, and there's a kind of subsequent question around citizenship. So for example, if someone applies for citizenship, particularly if that person's from a refugee background or a humanitarian background, the department will scrupulously look at those applications for inconsistency, and if they identify a record that wasn't corrected previously, they might send out a notice of intention to cancel a person's visa. Oh, look, I think and in terms of how quickly that has to happen, I think the wording is as soon as possible. But I would suggest that someone would want to get a freedom of information release first so they could cross-reference everything. And then they would want to provide their response to the department. Again, if this person was in Queensland and they held a refugee or humanitarian visa, they could be referred to Rails, and our new cancellation program could provide an initial advice. I think that's all the questions. So I guess I just might make a few closing comments, if that's okay, Kylie.
Perfect. Thanks, Kylie. Go for it.
Yeah, great. Okay, so I just wanted to say that it's our hope that the removal of the requirement that lawyers are also registered as migration agents will open up exciting opportunities for partnerships with Rails and other new ways of working in which lawyers and migration agents can work together with very disempowered asylum seekers and migrants and refugees, hopefully to achieve the best outcomes for these clients in a system that can be very unforgiving and is often stacked against them. My email address is on one of those first few slides if someone wants to reach out if they're looking to form a pro bono partnership, or that might be more Stacey, our pro bono coordinator, or if they're looking to move their community legal centre in this area, I'm happy to have a chat. And we also have that coordinating working group if people would like to get involved in that. Yes, I hope you found the information clear and helpful, and all the best for the rest of your day.
Thank you so much, Kylie, on behalf of everyone who joined us today. We had a great turnout, and thank you so much for sticking around and for your great questions as well. So please, when you sign off from this webinar, you'll be prompted to complete a feedback survey, which is really quick. If you could do that for us, that would be wonderful. And once again, thank you, Kylie. We'll see you next time, everyone, for our next webinars. Bye-bye.